So we are on the record in docket 22-01500. People of the state of Michigan versus DeAndre Holmes. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Aaron Housfield on behalf of the people.
Thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Holmes, the gentleman who's standing to my right.
And sir, you are DeAndre Dean Holmes?
Yes.
Okay. Ms. Housfield, this is the time set for preliminary examination. How are we proceeding?
Thank you, Your Honor. It's my understanding that defendant wishes to proceed with the examination. The people do have the necessary witness today.
All right. Is that your understanding, Mr. Palmer?
It is.
All right. When you're ready, you can call your first witness.
Thank you, Your Honor. The people would call to the stand Trooper Vincent Coakley.
Trooper, be right in front of me and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth under the penalty of perjury?
Yes, sir.
All right, you can have a seat right there. And speak as loud as you can because we got a fan going.
Okay. Your Honor, just before we proceed, I'm not suggesting he's going to do anything improper, but it appears he has a copy of the police report. I would just ask him to flip that upside down.
No objection to that, correct?
Not at all, Your Honor.
All right, you may proceed.
Thank you, Your Honor. Good morning, sir. Could you please state and spell your name for the record?
Vincent Coakley, Vincent Coakley.
Thank you. And are you employed, sir?
Yes, ma'am.
How are you employed?
With the Michigan State Police.
And were you on duty on June 5th, 2022?
Yes, ma'am.
And what did your duties that day include?
Regular road patrol.
And did there come a time on that date when you were in the area of Cedar Street and Miller Street?
Yes, ma'am.
Are you familiar with the Lansing city limits?
Yes, ma'am.
And is that location within the city of Lansing, county of Ingham, state of Michigan?
Yes, ma'am.
And what, if anything, were you doing at that location?
Regular road patrol, observing traffic.
And what, at that location, was there a vehicle that came to your attention?
Yes, ma'am.
What type of vehicle?
Black Chrysler 300.
And why did it come to your attention?
I first observed the vehicle for a front window tint, and then I observed the vehicle make an improper right turn.
And when you say you observed the vehicle, what roadway were you upon?
I was upon Cedar Street at that time. The vehicle made a right turn off of Miller onto Cedar Street.
And when you say you observed the window tint, could you describe that for the court, please?
Yes, the front driver's side and front passenger side window had window tint below 4 inches. So the motor vehicle code states that front driver's side and passenger side vehicle can have a 4-inch strip on the top of the window. Anything below that is a violation of the vehicle code.
And can window tint also be a violation because of the grade or coloring of the tint?
Yes, ma'am.
Okay. And could you describe for the court whether this was a very dark tint or a less dark tint?
It was more of a less dark tint.
And the violation was specifically because of the placement of the tint.
Yes, ma'am.
And did you notice any other driving, sir?
The improper right turn,
Could you describe that for the court, please?
the driver, Mr. Holmes, did not make a proper right turn, which is turned into the immediate far right lane of the curbside lane.
Right. And what did he do instead?
He turned into the far left lane, closest to the turn. Or second lane, is what we call it.
And what did you do next?
At that point, I called up to the vehicle and made a traffic stop on the vehicle
For what purpose?
for their improper right turn and the window tint.
And did you effectuate a traffic stop?
Yes, ma'am.
Did you approach the vehicle?
Yes, ma'am.
As you approached the vehicle, were you able to see into the vehicle?
Yes, ma'am.
Were you able to determine how many occupants?
Yes, ma'am. There's 2 options.
Okay. And where were those occupants seated?
Driver's seat, front passenger seat,
Which side did you approach, sir?
driver's side.
And as you approached and you were able to see the occupants in the vehicle, did you note anything of importance to you?
Yes, ma'am. I noted to my partner, Cooper Fabianchik, that the driver was reaching behind the driver's seat and moving very quickly.
When you say reaching behind, could you describe what you observed for the court?
I observed the driver hips thrusted forward out of the seat, reaching behind his driver's seat, and moving around with his right hand, moving something around back there as if he was attempting to conceal something.
Thank you. And why is that type of movement or something that you would call out to your partner?
It's a safety concern. When people aren't sitting still in the car, when they're moving very quickly as we're walking up to the vehicle, as if they're trying to conceal something in the vehicle that we don't know, or as if they're trying to hide something, maybe illegal substance or a weapon that could hurt us. So usually when we see people moving very quickly as we're walking up to the vehicle, we note it out to each other so we can make sure we're watching.
And did you continue approaching the vehicle?
Yes, ma'am.
Did you make contact with the driver?
Yes, ma'am.
Did you speak with the driver?
Yes, ma'am.
Do you see that person here today?
Yes, ma'am.
Could you please indicate for the court something that the driver of the vehicle on June 5th, 2022 is wearing today?
A white T-shirt with a pink Nike sign on it.
Your Honor, may the record reflect that the witness has identified the driver, I'm sorry, the defendant as the driver.
Any objection?
Not for the purposes of exam today.
Okay, without objection, the witness is identified. The defendant.
Thank you. And upon initial contact with the defendant, what, if anything, did you do, sir?
I asked Mr. Holmes why was he reaching behind his seat.
Did he give you an answer?
Mr. Holmes initially told me he was not reaching behind his seat. I continued to ask him, and he told me he was hiding his marijuana.
What did you do next?
I advised Mr. Holmes marijuana is not illegal. I asked him if he was continuing to hide something else. He advised me no. I asked him for his driver's license.
Did he provide you with his driver's license?
He provided me with an identification card.
And what, if anything, did you do with that identification card?
I returned to my patrol vehicle and ran him through the SOS.
Now, before returning to your vehicle, did you do anything else?
Yes, I asked Mr. Holmes to step out of it.
For what purpose?
His quick and furtive movements and the fact that he did not have a driver's license.
And what did you do with him, if anything, when he stepped out of the vehicle?
When Mr. Holmes stepped out of the vehicle, I asked him for verbal consent to search his persons. He gave me verbal consent and illegal items were found.
So at this point, you returned to your vehicle to do what?
To run Mr. Holmes through Lean SOS,
And what is lien?
Law Enforcement Information Act or network side.
And what type of information can you learn from lien?
You would learn driving statuses, if they had any officer safety cautions or any warrants.
And did anything, when you ran him in lien, did you learn anything?
Yes, ma'am.
And what specifically did you learn?
Mr. Holmes had several warrants out of several jurisdictions, and that he did not have a driver's license.
Did you confirm those warrants in any way?
Yes, ma'am. Through the King County Central Dispatch.
And upon determining that there were valid warrants in lien, what did you do next?
At that point, I placed Mr. Holmes under arrest for his warrants.
What,
And
what did you do next?
at that time, I asked Mr. Holmes, is he able to provide roadside bond?
And what is roadside bond?
Roadside bond is a bond amount that the court sets that he can pay while on scene of traffic stop, so he does not have to be taken into custody. That was satisfied.
And was he able to provide that?
While we were on scene, he was not. He asked if I could take him to an ATM. I advised him I would take him to an ATM to see if he could post roadside bond.
Okay. And did you proceed to an ATM?
Yes.
Was he eventually able to post that bond?
No.
Okay. So what did you do next?
After Mr. Holmes was not able to post roadside bond, we returned to the traffic stop. And then Mr. Holmes was under arrest and inventory search of the vehicle was completed.
And why did you conduct an inventory search of the vehicle?
Due to there not being a sober driver, the front seat passenger was intoxicated to the point where she was not able to drive. And the vehicle was parked in a Michigan public roadway. Was not able to do that.
So it was your intention to tow the vehicle.
Yes,
Okay. And as a result of that tow, you conducted an inventory search.
yes, ma'am.
Okay. And did you find anything of note during that search?
Yes, ma'am.
What?
I found a handgun that was located behind the driver's seat. It's a .45 caliber black in color.
And you said it was found behind the driver's seat, is that correct?
Yes, ma'am.
Okay, and was the location of the firearm consistent with where you saw the defendant reaching?
Yes, ma'am.
Did you determine if the defendant has a CPL?
I did. He does not.
I have no further questions at this time for this witness, Your Honor.
Cross-examination?
Thank you, Your Honor. Good morning, officer. Or trooper, excuse me. I have several questions for you. You initially conducted the traffic stop based on the illegal turn and the tint, is that right?
Yes, sir.
All right. At the time you initially approached the vehicle, did you know anything about Mr. Holmes?
I did not.
All right. Ever met him before that day?
No, sir.
So you approached the vehicle, he produced, I guess, an identification card, not a driver's license, is that right?
Yes, sir.
And you ran his name through the lien and found the warrant for child support.
Yes, sir.
I think you mentioned, and please correct me if I'm wrong here, I think you mentioned that there were other outstanding warrants, is that right?
Yes, sir.
Do you know what the other outstanding warrants were for?
I do not recall.
So the roadside bond, you offered to transport, or I guess did transport him to the speedway so that he could try to produce a roadside bond, correct?
Yes, sir.
If he had been able to post that roadside bond, would there still be a basis to arrest him?
No, sir.
So at the time, well, let me back up here. When you originally approached the vehicle, was there any basis to search the car?
He had open intox behind the front driver's seat. It wasn't something that I wanted to reach upon.
Okay.
But that was something that I didn't notice behind the driver's seat, open bottle Patron.
Okay. The other individual in the vehicle, there was another individual in the vehicle, correct?
Yes, sir.
And that was a female, correct?
Yes, sir.
And I think you indicated that she was intoxicated also, correct?
Yes, sir.
All right. And therefore she was unable to drive that vehicle away.
Yes, sir.
You ultimately produced what's called ultimately there was an inventory search done, correct?
Yes, sir.
And that inventory search, and please correct me if I'm wrong, the inventory search is conducted anytime the vehicle is to be towed, right?
Yes, sir. Fire department policy.
Okay. And so as part of the, that's what I was getting to, there is a Michigan State Police Department policy, correct?
Yes, sir.
And that just so we make a clear record here, that policy sort of lays out the method for committing an inventory search, or for performing, I should say, an inventory search, correct?
Yes, sir.
As part of that, are you familiar with the term of a UD-19? Do you know what that is? All right. Well, let me ask it this way. Is there a specific form that an officer or a trooper is supposed to fill out when they perform an inventory search?
UD-90.
I'm sorry. All right. Yeah, you're right. It's a UD-91. I have my numbers transposed. A UD-91. All right. So that's the form that is filled out anytime an inventory search, right?
Yes, sir.
And again, so we have a clear record that UD-91 would then list any other items found in the vehicle, correct?
Yes, sir.
Was a UD-91 performed as part of this search?
Yes, sir.
Do you know if the UD-91 was ever turned over to the prosecutor's office? That is. If you don't know that.
I do not recall.
Okay, fair enough.
If not, it's at close.
Okay. Now the firearm was ultimately located in the back seat. Is that right?
Yes, sir.
All right. Did Mr. Holmes ever make any admissions regarding the firearm?
No, sir. I read his Miranda rights and refused to speak to me.
Okay. And was the other female individual, I'm not asking you specifically what she said, but was she ever interviewed about the firearm, if you recall?
I do not recall.
Okay, that's fair. Do you know if the firearm came back as registered to anyone?
Get the police report to verify that.
Certainly. Would it help to refresh your recollection if you reviewed your report?
Yes, sir.
All right. Your Honor, may I approach?
May.
Sir, I'm going to hand you the entire report. I'm not sure which portion of that you need, but if it would help to refresh your recollection, please review the report. And then when you're finished, read silently to yourself. And when you're finished, turn it face down and look up at me.
Yes, sir.
Have you had an opportunity to review your report?
Yes, sir.
And did you find the answer to the question?
Yes, sir.
All right, and what is the answer?
The firearm came back no lean, unregistered.
Okay. Your Honor, may I approach the room?
You may.
Retrieve the report. Thanks. And the vehicle, I probably should have asked you this specifically while you still had the report, but the vehicle itself, was that also registered to my client, or do you recall? All right. Ultimately, nobody ever made an admission regarding that firearm in that vehicle. Is that correct?
Yes, sir.
What time of day was this? Was the stop ballpark for me?
It was dark unlit is what we would call it,
Unlit.
probably
Okay.
early morning hours.
Okay. So I guess what I'm getting at is it's dark outside.
Yes, sir.
Was the area that you originally identified the vehicle as having tint, was that an area that was lit by streetlights?
Yes, sir.
And so from your position, you were able to easily see that the tint on the windows, despite the fact that it was dark outside?
Yes, sir.
Understood. Thank you, Your Honor. I have no further questions.
Any redirect?
No, Your Honor, thank you.
May this witness be excused?
Yes, Your Honor, thank you.
Yes, Your Honor.
Without objection, the witness is excused. Any further proofs, Ms. Housfield?
Yes, Your Honor, thank you. At this time, the people would move to admit People's Exhibit number 1 it is a judgment of sentence, and that people will admit that pursuant to MCL 766.11B. I have shared this with defense counsel, but may I approach?
You may. Any objection to the motion to admit People's Exhibit 1?
Your Honor, I don't believe I have any legal basis to make an objection. I believe it's a self-authenticating document, and I don't think there's any basis for me to make an objection.
All right, so People's Exhibit 1 is admitted into evidence.
Thank you. The people have no further proofs, Your Honor. Thank you.
Any proofs from the defense?
Not today, Your Honor. Thank you.
Okay. Motion for bind over?
Thank you, Your Honor. At this time, the people have filed a complaint alleging that DeAndre Holmes did on the date of June 5th, 2022 at Cedar Street and Miller Road in the city of Lansing, Ingham County, Michigan. Count 1, carry a concealed weapon in a vehicle, specifically a Chrysler 300, and count 2 was in possession of a firearm as a felon. The court has had the opportunity to hear the testimony today of Trooper Coakley. I don't believe there's any question as to date or venue. The people have admitted the Exhibit 1, which supports the felony conviction for purposes of count 2. I believe the real question here, if any, by defense, will be whether or not there was a weapon attributable to the defendant. Certainly, the trooper testified that a weapon was found within the vehicle, and that the location of the weapon, which was specifically behind the driver's side, was consistent with the placement of the defendant's movements as the officer made approach and saw the defendant reaching behind him. I believe that by a probable cause standard, Your Honor, the people have satisfied count 1 and 2 and would ask that this matter be bound over to the circuit court on the complaint is filed. And I will note, I'm sorry, finally, Your Honor, that the witness, I did identify the defendant in court.
Any response to the motion?
Thank you, Your Honor. Certainly, Ms. Housefield has, I guess, hit the nail on the head in terms of the defense's response. I do certainly acknowledge and understand that this is a much lower standard than trial. This is a probable cause standard. I will point out that in the original charge, count 1, carrying concealed pistol or carrying concealed weapon, in this particular instance is charged, I guess, as carrying it in a motor vehicle. The jury instruction for that is Michigan Criminal Jury Instruction 11.1A, and it requires 3 elements. And as Ms. Housefield indicated, my argument would be with regards to my clients carrying or keeping the pistol. The testimony today supports the fact that the first element, that the pistol was in a vehicle that the defendant was in. My suggestion to the court would be that the second and third elements have not been met. Second, that the defendant knew that the pistol was there. I don't know that we've heard any testimony specifically related to that. And then the third element being that the defendant took part in carrying or keeping the pistol in the vehicle. Again, I don't know that we have any evidence that supports that. The trooper's testimony today, Trooper Coakley, was that he was not sure who the vehicle was registered to. The handgun came back as unregistered. my client never made any statement. There was another individual in the vehicle. It's unclear whether that individual ever made any statement, at least in terms of the testimony that we've heard today. My suggestion to this court would be that there is a lack of probable cause for count one because of elements 2 and 3. Certainly, Your Honor, then my argument would be that in following that, if there is no firearm that is attributable to my client, then count 2 must also fall, because if he's not attributed with the weapon, then he can't be a felon in possession. That is my argument for the purposes of today. Thank you.
Thank you, counsel. Any response?
Just very briefly, Your Honor. I think that for purposes of probable cause, the court can infer from the testimony of Trooper Coakley that the movements of the defendant are enough to provide probable cause that he knew that the weapon was in the vehicle and that he took part in carrying or concealing that weapon. Certainly, questions of fact are meant for the jury as the case proceeds to circuit, but for purposes of today, the people believe it's met its probable cause standard.
Thank you, counsel. So the court's standard is probable cause. This is a probable cause preliminary examination. It's much less than beyond a reasonable doubt. Beyond a reasonable doubt is the conviction standard, probable cause being the preliminary examination standard. And probable cause is essentially what it says, did it probably happen? It's somewhat less than preponderance. That's the only standard higher than reasonable suspicion, but it's a lower standard. There seems to be no argument that the stop was made at Cedar Street and Miller Road in the city of Lansing, Ingham County, state of Michigan. The defendant was driving the 300 Chrysler. So identification was made. This did happen on June 5th, 2022. And so both counsel are right. The real question is concerning the offense of both charges. There does not seem to be any disagreement, or at least not at this point, that the motor vehicle stop was based on twofold: an improper right lane, an improper turn, and a violation of the motor vehicle code concerning the window tint. The stop was made. I think important to the facts are that initially Trooper Coakley, who testified, indicated that he saw gestures going behind the driver's seat, which would lead one to naturally look back there. There was an indication that the defendant made that it was marijuana at the time. I think the trooper was accurate in their testimony that this announcement was made for safety concerns. Identification was made of the individual through an ID card, not a driver's license. The card was run, and there were multiple warrants issued. The one that in this case would be the support warrant that was the subject of the actual arrest after roadside bond was not able to be committed. And so there was the attempt by the trooper to have roadside bond be permissible, and it wasn't successful. Therefore, there was an inventory search pursuant to policy, and the policy would indicate that the inventory searches, of course, are not a search for contraband. They're a search for safety purposes, safety of the defendant, and accountability of the trooper. So the inventory search was made, and the firearm was located. There does not seem to be any dispute that it was a firearm and it was a gun in this proceeding. So the elements concerning the crime are a pistol was in a vehicle the defendant was in. We have that by probable cause evidence. The defendant knew the pistol was there. At a probable cause standard in regard to the gestures that were made, I believe that's been met at a probable cause standard. I can't speak to a reasonable doubt standard, but I certainly can speak to a probable cause standard. And the defendant took part in carrying or keeping the pistol in the vehicle is an inference made from the defendant knowing that the pistol was there, which I think is met at a probable cause standard once again. So I believe that the elements of count one are met, that the defendant did carry a dangerous weapon, a handgun, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, a Chrysler 300. With the finding of that, the second charge, count two, of possession of a firearm by a felon, did possess or transport a firearm when eligible to do so. I have to do so because of a prior retail fraud in the first degree. I have plaintiff's exhibit 1, that was admitted, a judgment of sentence on a retail fraud in the first degree that was prior to this occasion, and that this felony is punishable by imprisonment of 4 years or more, and the requirement for gaining eligibility has not been met. Therefore, I believe that the people, through the testimony of the trooper, have met their burden at a probable cause standard to bind the case over to circuit court on counts 1 and 2 as charged. I will indicate for the record that the bind over is available for signature after I place the date in. Anything else for the record, Ms. Houseman?
No, Your Honor, thank you.
Anything, Mr. Palmer?
No, Your Honor, I would just ask the bond continue.
Any objection to bond being continued?
No objection, Your Honor.
Without objection, bond is continued, and I have the paperwork to be signed. There's a place board running. Is there not? Only for the waiver. 2-01500.
Nothing to give up.
Nothing.
Thank you.